Earlier this week, I was contacted by an attorney who had the unfortunate circumstance of having a paralegal who left his firm, take a number of clients with him on the way out the door to a new law firm. And the question that was raised was whether or not they had a viable cause of action against that former paralegal and the new attorney's office that the paralegal was going to for tortious interference. And unfortunately for this law firm, the answer is, well, perhaps you could craft a complaint that might survive an initial motion to dismiss, but in terms of the long-term prospects for the success of a lawsuit based on tortious interference, chances are it wouldn't really do rather well or survive. And here's why. Unlike many other professions, lawyers have a particular set of rules, ethics rules that govern their conduct, two of which pertaining to client relations that would make these cases difficult, if not impossible, to win. Number one is that under New York Rule of Professional Conduct 1.16b3, a client can basically terminate an attorney at any time. There's a second rule of professional conduct, which is 5.6a1, which the commentaries there indicate that a client should be freely able to choose whichever attorney they want within certain limitations, but the general rule is a client should be able to choose the counsel that they would like to represent them in any action. So to the extent that anyone would take actions that would impede that, which would include, for example, any type of restrictive covenant with respect to an attorney, not allowing them to take cases with them when they leave, that would come up squarely and conflict with those rules of professional conduct. There is one carve out, one limited exception, which was recognized in a 2021 case in the First Department in the Gennarte case, where the court held that where the paralegal may have been engaged in illegal activity in terms of how they came about to try and divert or solicit these cases. And there are certain types of solicitation, client solicitation, which are illegal, such as using runners and people stationed in emergency rooms. Since those actions would constitute a crime, under those circumstances, it might satisfy the wrongful means prong of a tortious interference claim. And under those circumstances, if the former law firm could prove those claims were true at trial, they might actually win. But otherwise, the answer is such a claim would be very unlikely to survive. If you have any other questions about tortious interference, please feel free to reach out to me. My number is 516-791-5700. Thank you, and have a great day.